going to run through CGP&H's presentation. And if Heather, if you're ready with the share screen, CGP&H is going to run through their presentation of how they will be administering Bedminster's affordable housing program, and questions and answers for CGP&H will be at the end of her presentation. The attorney for BHHC who filed that declaratory judgment is actually trying to get in, and if he cannot participate through the Zoom session, we will conference call and get him on as well. So right now, Heather, you've got the share screen. Your program is up. I'm going to go try to get the BHHC attorney on a conference call.
Great. Okay. So my presentation is going to go over the administrative agent services that CGP&H is going to provide to Bedminster Township. As the mayor said, we started officially January 1st of this year, but we are well on our way. Just some background about CGP&H. The mayor gave us some very nice kudos, but we've been around for a while, since 1993. We work in over 80 New Jersey municipalities with sale and rental projects, affordable projects. We have a experienced and growing staff of 32, always looking for new people. And the staff that's dedicated to doing the work that we do in Bedminster is 15 people. We have people who are certified by AHP&J and who are very knowledgeable about the rules and regulations for affordable housing. And as the mayor said, we also have licensed planners who specialize in housing elements and fair share plans that see the bigger picture, the overall picture of why we do this. So we work as the administrative agent, as we do in Bedminster, for Cranford, Edison, Montgomery, Woodbridge, and then we also have sales and rental units in other towns across the state. For the township, our role is to assist in keeping the inventory, all of the affordable units, creditworthy and in compliance. So that's our job, is to make sure that the units that you have stay affordable if they're supposed to be affordable, keeping track of all of the units that are deed restricted. We will answer affordable housing questions and concerns from residents and applicants, and generally working to further the goals of your affordable housing plans. For the residents, we work with them to sell or refinance their affordable units, and then also to answer their questions, to guide them through the procedures and to let them know what the rules are. So for the residents, this is in general. If you want to sell your affordable housing unit, you will need an intent to sell package, and you can contact us through homes@cgph.net to get that. That will tell you what your maximum resale price is. We'll give you some information about the photos that we need to show off your unit to its best. You'll sign that and send it back to us, and we'll be on our way. At this point, we started advertising in November, and we have 1,000 people on the waiting list for Bedminster. Now, that's not all for, that's for all the units there, but it's a good start on getting a really good waiting list so that you don't have to wait to sell your unit. We will refer buyers from that waiting list based on their eligibility and their household size. And you'll get a list of people. There'll be contact between you to see the unit. Once you have someone who is interested in buying your unit and you've agreed on a price, you can go under contract. And at that point, it's going to be a fairly traditional real estate process. We hope that you contract with an attorney, because it is a real estate transaction, to help you through any negotiations that have to happen. Once you're under contract, we'll calculate your recapture amount, the amount that will be paid to Bedminster at the closing. CGP&H does not charge the buyer or the seller for the work that we do on this transaction. And before the closing, we'll complete the deed restriction documents, and you can ask any questions that you have about those prior to closing, and those will be available at closing. If you want to refinance, a little bit simpler, contact us at homes@cgph.net. We'll let you know the maximum amount that you can refinance for. We do charge a fee for the work that we do, but we will work with your lender to complete the subordination process. So hopefully it's a pretty easy process to get through, and you don't have to get too involved in that. Other services that we provide, if you need to make a change to your deed or mortgage, add someone, take off someone, that would be done through us. And also we're available to answer any of your affordable housing questions. A lot of people have asked about the improvements that they can get credit for. These are the pre-approved improvements for the that would be considered in the recapture calculation. Air conditioning installation for Village Green, where it didn't have it, a unit didn't have it. Neutral carpeting, ceiling fans, flooring in the kitchen or bathroom, washer, dryer, refrigerator, and dishwasher. So in order to get credit for these, we would need the receipt or the invoice with the homeowner's name and address. And we do apply a 10% depreciation rate per year. So if you put in a new washer and dryer 5 years ago, you would get credit for 50% of that cost. If you know someone who wants to be on the waiting list, you can direct them to affordablehomesnewjersey.com. This is a picture of kind of what they'll see. They can create a profile on this webpage and update it as they need to. If anything changes, they would want to go onto the Bedminster ownership waiting list. If someone doesn't have web access or an email address, they can call us at that number, and we will help them through that. We also do things by mail if we need to, certainly. And then once we get to someone's name on the waiting list, we will reach out to them via email and send them a listing of your unit if you're selling. And so that's why great pictures are very important. So it shows off your unit to the best, to its best. And that's generally basically the process. I know that there are very specific questions, and there's little ins and outs, and certainly other things that go on, but that's generally it. And we are happy to take any questions or now, or you can always give us a call or send us an email.
I have a question.
Well, hang on. Do you want to do it like we do it with our meetings and have people react and then respond?
Yeah.
Otherwise, I think we're going to lose the some control over it. I mean, everyone's going to have a chance to have a question here. We're just going to try to implement a system that makes some process or an order here. So if
I think the person that wants to speak now has a lot of input as to what's going on with this lien. So if you could let her speak, she could get right to the heart of what has caused this meeting here about this lien situation. So
Okay.
can you allow her to speak?
since we can't
So
follow,
we can-
go ahead and start.
No,
Okay,
this,
can I
this is
start?
this is in particular about the lien against your house
Okay,
that's going on right now, which is affecting our ability to refinance. And so I think we need to address this main issue. So if
Okay.
you could let her speak, please just let her bring this up and we could get through this.
Okay. Can I ask the question about the financing, Mr. Mayor?
Identify themselves and give me their address, please.
Excuse me?
If you're going to be speaking, I need to know who you are and your address.
16 Village Green Road, Debbie Ryan.
Thank you.
Mr. Mayor, I'm not sure you're aware of a couple of things.
I'm gonna try and
I am one of the people who tried to refinance. I have the email from this CGP&H in front of me, which I forwarded to my homeowners association. Not only do they want to charge us $175, they want a copy of my loan application. My social security number is none of their business, nor is my W-2, nor is my bank statement. That's number one. Number two, and I'm reading directly from it, they want to know why I am seeking the loan. My personal finances are none of their business. My finance company doesn't even ask me what I want to do with the money. They're charging me $175, plus they want a self-paid address label. Are you aware, is the Bedminster attorney on the line that they are asking for confidential information from me? That is none of their business?
So this is a refi question directed at CGP&H's process.
I'm looking right at it, the email they sent me. They want a copy of my loan application and they want to know why I'm seeking the loan. Are you kidding me?
So the
business
reason
is it of theirs?
So Heather
Is
Mahali,
the attorney on the line?
this is a question for CGP&H and Heather, if
Yeah.
Heather's ready. Heather,
Yes, I can answer that. So the reason that we need to see your loan application or the commitment or something, we need to see something from the bank that shows the amount that you are seeking to refinance for. We need something, an authorizing document that shows what you're refinancing for, because we can't, you could tell us one thing and then get a loan for something else. So we need to make sure that you are getting a mortgage for the amount for an amount that is less than or equal to what you're able to refinance for.
But if
Why
you
is it your
notice,
business?
a copy of a loan application includes all documentation. So you are
No,
asking confidential information.
we don't need the supplemental documentation. We just need the application
And
or
why?
the mortgage commitment.
Would you ask me what I'm going to use the money for?
We
Are
do
you
that
kidding
too.
me? I'm
we
looking
do
right
that.
at the email you sent me.
Wow. Okay. So we do that in order to make sure that you're not being pressured in any way to refinance.
Oh, please, are you kidding me? Is that your, Mr. Mayor, are you hearing this? Is our
Okay,
attorney hearing this?
Excuse us, we are 100 people here, and we would like to hear the presentation from this company who's taking over, and we would like all the information. We don't want to hear somebody fighting. If you have any personal questions, why don't you call them tomorrow?
Why don't you just
No.
let her speak
No,
about what's going on with
this
this
meeting is
meeting?
about. This
The
is
meeting
what
is
this
about this
meeting is
lien.
about.
No,
The meeting
I
is
want to
about
know
that
what
you
you're
can't,
asking me.
if you go for a car, if you want to buy a car and you want to get a loan, you're going to have a lien on your credit. That's what this is about.
This
So this
affects
is the time
everyone.
to bring this up.
And again, no one is answering my question. What am I going to do with the money? Are
Mahali,
you kidding me? My finance company doesn't ask me that. Again, is the Bedminster attorney on the line?
Heather Mahali is addressing your question, and she's already said she doesn't need all your information. She needs certain of that information. And So Heather, let's run through the information that CGP&H requires to help process the refinancing. And just as the other woman who cut in, if there are specific questions that are better taken offline, you and Heather can have that follow-up conversation later on, but let's talk in generalities, Heather. What information do you need?
Let's talk
We
about the
need-
lien. That's what we want to.
Please, Mahali, answer the question.
That is the question. The lien is the. Not a
So
get
we
a loan
need,
anywhere.
we need a copy, something from the bank that shows what the loan amount requested is. So it can be the application, not the supplemental information. It can be the application or the mortgage commitment, something from the bank, like I said, that shows what the loan amount requested is. We need a subordination from the finance company or the title company that whatever they want to see, the subordination language for us to fill out. We ask for a shipping label to send that back so that we can make sure that it gets to them, not through the mail, and that's pretty standard practice. We do ask owners that, and I think that the reason that we ask kind of goes back to the days of predatory lending when some people were pressured, some people were, banks were asking, we're calling people and saying, hey, you should refinance. You've got lots of equity. So I think it's a throwback to those times. We just want to make sure that you are not being, like I said, pressured to refinance from a bank, that it's something that you are choosing to do.
That's
And yes,
ridiculous. That's ridiculous.
We do charge $175 because this is work. It takes a while to get all of these things together, to coordinate all of these things.
Isn't it
And
what
that,
They're none of your business. Where's the lawyer in this? Is there a lawyer on here or not? The last association,
we-
I
Can
refinanced
we
with the last
please
association.
move on? Can we please
Heather-
move on? This is
Heather-
not,
This
we
is
don't
what we're
want to
talking
hear
about.
this.
Heather,
We
can
don't-
Heather, can I ask a question, please?
sure.
Just have a name and address for the person who's asking.
Yes, Rachel, 88 Cortland. My question
Hi.
is this. Hi, thank you for taking my question. My question is this. The paperwork said that there was a lien on the property. Will that prevent me from going to get a mortgage on a new property that I want to buy?
Yes, it will.
That is
You're gonna have to mute her.
Heather, can you answer that? Because I want to know if we go to sell and there is a lien on the property, that was my biggest concern about getting that lawsuit letter.
right.
Will that, please let me ask my question. Will that, will it show up on a credit check? Because my credit is very good.
Heather,
I want to know if it will show up in a credit check and will it prevent me from bidding on another home?
Rachel, this is Mayor Jacobs. Sal DeFazio, who is the BHHC attorney, who is proceeding with the declaratory judgment regarding the recapture fee, has joined the Zoom session. And it sounds like Sal, that question is probably better directed at Sal than Heather. So Sal, if you're prepared.
yes.
Oh, wonderful. I'm glad he's there.
Hi, I am here. I apologize. I was trying to get on, but unfortunately, we have so many interested parties that after 100 people, it locked everybody out. So, I was listening, and I am here now. And your question is, as I understand it, will the lien that would be imposed by virtue of the declaratory judgment action, in other words, the judgment that would ultimately be on your property, is that going to affect your ability to buy another property? Is that what you're asking?
Yes, I want to know if that, because my credit is perfect.
Okay.
And
Our understanding is that because this judgment is solely for the purpose of documenting the responsibility for the recapture fees, that it will not affect your credit. If any, and I have told counsel for various residents who have called, that if they have a problem in that regard, if anybody has a problem in that regard, we will issue the necessary letter explaining that to resolve the credit issue. But at the end of the day, we do not expect that's going to be a problem for you in terms of getting financing or refinancing your home or for any other reason. Now, we will have a subordination agreement that Heather will have access to, so that you come to Heather, you say you want to, for instance, refinance. As long as it meets the requirements of the affordable housing parameters, then the subordination agreement will subordinate the judgment or the lis pendens to your refinance so that it won't block it. You understand?
Yes, but my question is, I'm not looking to refinance. I'm looking to possibly put the home on the market at some point. And I wanted to, so I want to know, will it affect me going to, say, Chase Bank or Bank of America and getting a mortgage for a new home? That's what I'm most interested. I'm not interested in refinancing.
Well, here's the problem. I know that smacks of a legal question, but I really can't give any of the residents a legal opinion. Our opinion is that it will not affect anybody's credit. It will not cause you not to be able to, you certainly are not going to affect your ability to sell the property. And as to your ability to buy another piece of property, it's our understanding that it will not have any effect on that. If it creates a problem, we will issue the necessary correspondence to resolve that.
Sal, may I say something? The woman that was on
I want to just
before-
ask. I want to just ask a question about what that letter would.
With your question, please.
Sal, what would that letter include? In
That
other
letter
words,
would advise the credit agency that is causing a problem what the judgment is about, that it's not for dollars. It was not a collection matter. It was simply to effectuate the recordation of a lien obligation that all of the owners knew about at the time they purchased their units. And
that's the problem, because that was never explained to us, Sal.
What was never explained to you?
That there was a recapture fee.
Well, I don't know when did you purchase?
Over a year ago.
Where did you purchase?
Bedminster.
No, I know that. Which development?
Oh, Cortland.
Do you know if the unit that you purchased was one that was still under restriction, or was it unrestricted as of the time you purchased it?
I thought it was restricted.
Was the BHHC involved in qualifying you as a purchaser?
No, I think just the bank did.
Okay, so then it may not have been restricted because you would have been qualified as a purchaser if it was still under affordable housing restrictions. Now, if that happened and you purchased after restrictions were lifted, and you bought from a seller in the community, and your title company did not alert you to the fact that there was a recapture fee that was due from your seller to the BHHC, therein lies the very reason why we're doing what we're doing.
So my unit might not be restricted?
Be restricted.
I'm sorry?
Are we live here? I mean,
Yeah.
It may not be restricted in that sense. And that's why, each person has to look at his or her situation uniquely.
And where would I find that information out?
It would be in your title work. When you acquired your property, you received a deed, and you received likely what's called a title policy, right?
Yeah.
It would be right in your title policy. It would talk about.
Well, it should be, because the master deed, there are master deeds that govern the operation of the affordable neighborhoods.
Okay.
Built into that master deed, and this is exactly the litigation that Mr. DeFazio is describing. Built into his master deeds is a provision that says there's a recapture fee owed back to the affordable housing program when the unit sells during the restricted period, during the time that only qualified residents, in other words, that they are income qualified, that they fit the low or moderate requirements. So when during that restriction period, there's a sale from an owner to a new purchaser,
Right.
there's a 20% recapture fee that goes back to the affordable housing program. When the units, and Bedminster is the first town in New Jersey to go through this, because we were the subject of the first affordable housing litigations. In 2017, I believe, Parkside came off certain of the restrictions. And in 2018, Cortland, parts of Cortland, unless those units were otherwise extended, came off restrictions.
So if I had to sign something that said, there would have been something to sign then that I'm staying restricted or
Either if you were not income qualified when you purchased your unit, either there was a mistake made by BHHC at that time, or your seller should have sold only to someone who is income qualified, or your unit that you bought was no longer in the restricted, was no longer subject to the affordable restrictions. However, there's a chance that the unit you bought should have been the subject of a final recapture fee. So once the restriction period ends, the master deed has provision that says the first market sale has a recapture fee associated with that transaction. And then after that transaction, that unit is no longer subject to recapture fees. But it's the first market sale. 20% of the first market sale is supposed to be returned to the affordable housing program. So it may be that in your situation, you may be living in a restricted unit, and maybe you should or shouldn't be, or you bought a unit that was no longer in the restriction period, and your seller should have paid a recapture fee, but may not have. And I'll let Sal talk about, once again, the purpose of the litigation. Just so everyone knows, I am posting a letter tonight that will be on the Bedminster website and will actually be mailed to residents that lays out, oh, it is up there now. It's actually, Judy Sullivan says it's actually up there right now. That lays out why the declaratory judgment was being sought by BHHC. And part of it is for the very reason you just discussed, is that transactions were happening and sellers and buyers and title companies and lawyers were not picking up the language in the master deed that describes that final recapture fee.
And
Let me, if I may, I just want to clarify one thing first.
Right, just I wanted to clarify one of the mayor's comments.
And this is Committeeman Stevenson.
Yes, thank you. The document of record is not entitled the master deed. It's a document, in this particular instance, it's Parkside. It's called the Parkside Neighborhood Condominium Declaration of Covenants, Conditions, and Restrictions of Resale. These documents are recorded in Somerville. This document was recorded in book 1648, page 662, 663, 664, and so on and so forth until completed. These documents are filed in the public record for a purpose. That purpose is to put the public on notice as to what is happening on a piece of property. That's why folks hire attorneys when they buy property, to run down title, to make sure they know what they're purchasing. So I want to be very clear about something here. There is no fee that is being asked of anyone that did not exist the moment that this document was filed in 1980, fill in the blank. Okay, that scheme was set 30 years ago. The problem that we have, and why we're all on a Zoom call together today, is because it wasn't implemented correctly. Or better yet, it was implemented inconsistent. And so now we need a court to say, what is the manner in which this is going to happen? And that is, turning it back over to Mr. DeFazio, the purpose of his lawsuit, and Sal, if you'd like to chime in,
I just would like, thank you, Doug. I'd just like to clarify one thing. The mayor said a recapture fee of 20%. The recapture fee is not 20% of the sale price. There is a formula in those restrictions, the covenants and restrictions, and it is not 20% of the sale price. It's actually based on that formula. It's more like 20% of the difference between what you paid, what you included in improvements, what your expenses on sale were. It's a much lower number, but be that as it may, I didn't want anybody to be misled.
Yeah, and Sal, Heather did talk about the calculation of the recapture fee. It's essentially 20% of the net profit or 20% of the windfall. So
essentially. But you know, I just want to make it clear. I'm sorry, I wasn't on when Heather was speaking, so I missed that.
Yeah.
But the other thing I want to make clear to everybody, and the young lady that I was speaking to, was it Heather?
Rachel, that was Rachel.
Rachel. Your situation falls into one in which you should speak to your own personal counsel and have them call me. And I'm taking calls from counsel. I have taken calls from counsel from a number of people. Now, we are going to be putting a stipulation on the website that will make it easy for a lot of people. And I've had great cooperation from counsel and from Rich Mastro in the legal aid offices. But look, I want to make it clear to everybody here. It's as simple as this. This lawsuit seeks nothing more than to document what you already agreed to when you bought in the hills by virtue of the master deeds, the covenants, and the restrictions.
Yes, but may I say something here? People are now being affected because they've been denied their letter, a line of credit or refinance, and that is what is the issue here.
Who's this speaking?
I am speaking, June Lamada, and I know several neighbors.
June, all anybody would have to do if they were trying to obtain financing is have their attorney contact my office, and as long as the financing they were trying to obtain was within the limitations set forth in affordable housing restrictions, then under those circumstances, we would do what's a subordination agreement is what it's called, and we would subordinate the list pendants so they could complete their refinance. It's very simple.
So the subordination is the one paying $175 and revealing you have to pay $175 to get the subordination. Is that?
No, there's no charge for the subordination.
That's not the email I got. That's not the email I have.
From whom?
Heather.
CGP&H would not issue the subordination. The subordination you're asking for is a subordination of the notice of lis pendens that encumbers the property. That is
come from my office.
Okay, that's from your office. So we still have to go through that other procedure.
There'd be no charge for that from my office.
From your office. We still have to also go through the other
attorney
175 and getting them to approve the refinancing.
That it's not part of my involvement here. You can discuss that with Heather. I gather that was discussed before. That has nothing to do with my institution of the litigation.
Okay, so you.
Hi, Mayor. I have a question. Can I ask now?
Sure.
I'm from 15 Mountain Court.
Yes, please.
50 Mountain Court, we received a summons letter where it's asking us to respond. So do we have to respond even though we are not opposing to pay the 20%? Number one, I am not selling my house now. And then I am not opposing to pay the 20%. But in the first page of that summons, it is asking us to pay $175 and then submit this letter, your response letter in the court. If you are not submitting the letter, then the verdict will go to, according to the judgment, will go to the plaintiffs. Then you have to pay the court fees and all the expenses, whatever they incurred.
There will be no court fees.
Let me take that question. So that is a great question. So if you contest the recapture fee obligation that's in the master deed or the affordable housing provisions that Committeeman Stevenson mentioned before, Sal DeFazio has put together a stipulation. I'm going to turn it over to Committeeman Stevenson, who actually is regular expert on this type of subject.
Right. So we recognize the fact that essentially BHHC has parachuted into your lives and said, hey, here's a lawsuit, Merry Christmas. Okay, we understand that. We understand how that was received poorly. We get it. For those of you who are saying, okay, great, now I understand the issue, but why are you bothering me? I still have to take a day off of work to go talk to an attorney, or I've got to call legal services and I can't, do what I was needed to do. We get that. So Mr. DeFazio has agreed that if you agree with the fact that you, A, purchased your home as an affordable unit, B, you were duly served with the summons and the complaint, C, you have no objection to the idea of this 20% recapture fee on your gain if and when you sell, and 4, you wish to receive a copy of what the court ultimately decides, but other than that, you don't care what's going on here, then the stipulation is for you. Okay, go to the website under affordable housing, government, click affordable housing, and you'll see a stipulation there.
Or call Judy Sullivan tomorrow morning. Yeah, Judy's giving me the stink eye for saying that. So you can either go to the township website, as Committeeman Stevens said, go to government, click on affordable housing, and there will be a copy of a stipulation that you can print up. If you don't have the means to do that, you can come down to town hall and the township staff will take care of that for you. That stipulation will then go to Mr. DeFazio.
Mm-hmm.
Then you're done.
Right, so then what happens is Mr. DeFazio at some point will file that with the court to say, yes, court, I did serve Mary Smith, by way of example, and here is the stipulation from her, and she's agreed that she's been served, and she doesn't contest what the requested relief is. That way, the precious dollars that are being spent, and believe me, we don't like the fact that it's happening, but it's spent on the merits for the folks that are sitting in that particular fact pattern where they purchased and believe that they purchased an affordable unit, so they have a reason to say that it doesn't apply. There may be, and there probably are circumstances like that, but the point of why this all happened was because it was required by the courts. So I need you to understand that too. This is not something that we did that the BHHC wanted to. It's expensive to have to do it, but it was what was required.
Well, in the letter that we got today from Shelley, it said that you were trying to get this thing to just be dropped. And is that is it like a lawsuit that's being dropped, or?
Shelley.
Shelley sent us the letter from the lawyer today by email, and Shelley Magyar, and it basically said that, they didn't like how this was handled and the way we all were subpoenaed like this, and they were hoping that this whole thing could be dropped. And is the stipulation, would that suffice for whatever's going on here?
No, let's let Sal take that. That was definitely not a letter coming from the BHHC attorney or for the Township of Bedminster attorney.
No, that letter certainly did not come from me.
But so
We
Sal,
are not dropping the litigation. The point of this litigation is simply to confirm the obligations that already existed. I do want to clarify one thing. The mayor said the court directed us to do this. A prior decision of the court essentially required that all of you be given notice of what we were doing. We weren't directed to do this, and I don't want anybody to be misled in that regard.
We didn't get notice.
So,
Let me continue my question actually.
Prior to
well,
doing this,
Aruna,
we didn't get the
if I may
notice.
finish, Aruna. Here's the
No,
one
what
thing-
I'm saying, if I understood properly.
I heard
you're
you, but I heard you, but let me please say something, okay?
Uh-huh.
To all of you, it is my ethical obligation to tell you that while I'm here to answer questions, I can't give any of you legal advice.
Mhm.
So I
Right.
preface everything I am saying by saying what was in the summons, which is you can speak to your own counsel, you can have them call me, you can speak, if you can't afford counsel, you can speak to legal services to get counsel. And please, I'm not being rude if I can't answer a question which would sound like I'm giving you legal advice. So when you're asking me, so if I don't want to do anything, I could do this, I can't answer that question. I'm
No,
suggesting
we are,
that you
I'm
confer-
not asking that. You are asking that we have to go to the website and then print out the stipulation, and then we don't need to pay any legal fees or a court, right? I had to submit that letter to the Mr. DeFazio, right?
Well, what I'm saying on a broader scale, Aruna, is nobody, there's language in complaints typically about that. We are not going to seek legal fees from you folks or costs. This is something, all we're seeking is the declaratory judgment that says that the recapture fees are due. That's it.
Yeah, well, we already knew that we owed 20%,
Yeah.
and all this happened, and now, you know, what,
Who's this speaking?
I'm June Lamata.
Now, June, I don't think you're getting the message. We know that most people knew it. In fact, most of the people I speak to acknowledge that openly. Well, I know that I owe that. Why did you have to do this? The answer is, I'm not accusing anyone on this call, but there were people after their homes came out of restriction that sold their units and didn't pay the recapture fee. And what you all need to understand is that the recapture fee monies are used by the administrative agent, formerly the BHHC and now Heather's company. They are used to ensure that the next generation of people after all of you, get afforded an opportunity to live in affordable housing. If you don't have that, all the units get sold off, you wind up with no affordable housing anymore. So
I know, but you know what, the bottom line is the people that didn't pay this 20%, when they had to go through the association in order to sell the home.
No, they didn't. No, they didn't, June.
It was outside.
No, what you don't understand is this. If you sell your unit while it's under restriction, the association has to be involved because they have to qualify the purchaser, etc. Once you come out of restrictions, the association doesn't have to be involved to qualify the purchaser because it's a fair market value purchaser. So you have real estate agents helping you get your deal done. So the BHHC wasn't necessarily notified, and as a result, the recapture fees weren't collected.
Okay.
Can I ask a question? I hope you can hear me. I don't even know.
Sure.
I don't have a problem with the 20%. I fully understand that. So my question is, you pay the 20%, deed restriction ends, correct? So after the deed restriction ends, you're still entitled to 20% of the sale. But is it 20% of the full market value I'm selling it at, or is it 20% at the year the deed restriction ended?
Okay, stop for 1 second.
It's calculated.
The judgment and the deed restriction stays on the property until after the first sale, after restrictions are lifted.
So you're entitled to profit at fair market value, which I don't think is fair.
Yeah, they get full market value, and that part, I see. We have to look at the original deed that we signed. Are these all changes to that, or
no? These are all in the original master deeds and the covenants and conditions.
So I don't mind giving 20% up until when the deed.
It's going to be a market value if the price is
now. Shouldn't be allowed to have that at fair market value.
Guys, I'm going to say again, it's not 20%. It's actually less than that, less than 20%
It's the gain. It's the gain on what you spent versus what you're going to sell.
20% of the gain.
I fully understand that, but the gain's going to be higher if it's fair market value.
Sure, exactly.
Sure, a lot higher. Hopefully.
Sorry to interrupt. I have only one final question. I didn't completely get the answer for my question before. I don't have any problem to pay anything, but what are my respond to this summons? Can I ignore it, or can I, if I ignore, then the first page is saying that I have to pay the court fees and everything. So what is my immediate action?
Mayor, this is the mayor. And what's we got your address before, but what's your name?
Aruna, A-R-U-N-A.
Okay, so I am posting a letter that's actually on the town website and will actually be mailed to all the folks in the affordable units that actually lays out your question. So essentially there's three options. Mr. Stevens laid out one of the options. If you agree that there's a recapture fee and that you were served by Mr. DeFazio and you want to know what's going on with the litigation as it continues, sign that stipulation, come either pull it off the website or come to town hall and it'll be made available for you and you can sign it. Goes to Mr. DeFazio, you'll be on record that you agree and that you stipulate to the terms of that recapture fee.
Okay.
If you do nothing, you'll get noticed by the courts of when a final decision is made, but you will be still bound by whatever the courts ultimately decide. If there's a third option, if you disagree that there's a recapture fee owed, then you are more than entitled to contest and fight the action that Mr. DeFazio has filed. So it sounds to me that you're either in the, I don't want to do anything, or I'm okay with the stipulation.
Okay.
What is the?
I'm
court-
okay with the
what is that
stipulation.
court
All I
agreeing
wanted to,
on?
wherever it wants to be signed and then get out from this without paying any attorney fees or filing a court fee to
Right.
send my respond and all that stuff.
Is there now a lawsuit that the court, it's going, that is being in the courts right now against this whole thing? Like, is there legal action being taken against this?
Sal, has anybody filed an answer?
I don't know what that question means.
Yeah,
Nobody,
Filed an answer?
no one has filed an answer to the complaint contesting it. No one has filed any kind of counter legal action, if that's what you're asking.
Yes, that's what I'm asking.
No one has filed anything, and no attorney has contacted me saying what you suggested before, that an attorney is saying that they're contesting it. Now, there may be somebody who wants to contest this. That is certainly their civil right to do that, their legal right to do that. But no one has done anything of that nature so far.
But we got the letter today.
That letter did not come from the town or from Mr. DeFazio. That's someone who was trying to put together a group to fight it. And
May I ask who the attorney was that issued that?
you're more than entitled to participate in that type of litigation.
May I ask who the attorney was that issued that?
Hang on, I'm trying to pull it up
You're
right
doing that
now. Continue, as soon as I
You're
pull it up, I'll
underneath
get
the-
it. It's not the attorney, I believe it's the Village Green Association. I'm pulling it up right now, got it
Excuse
today.
me, my name is Nelson.
He
Nelson
came from
Caballero
the
from Village
property
Green.
management people, Access Property.
Can anyone hear me?
Yes, I can hear you.
Hello?
Yes, thank you.
Okay, thank you. I
What's
have a
access?
couple of questions. So I bought my unit in Village Green in 2013, right? Under my contract, I actually signed, I was aware that there was a recapture fee. I'm not contesting that. And as a matter of fact, with my contract and what I signed, there was an extension, because it is my understanding that the restrictions of Village Green are for 40 years, which that makes them to expire on 2025. However, it is also my understanding that new sales get extended for another 30 years. So I've always been aware of that, right? So when I received the civil action summons, the lease pendants, and all these declaratory judgments, I mean, I was very concerned for a couple of reasons, right? One is the wording. This says that if we don't act within 35 days and file a written response, right, then we could be being responsible for. And I know, Mr. DeFazio, you already stated that you're not seeking a monetary. This is not a monetary litigation. However, my question is, if nobody answers, because like in my case, I'm not contesting the recapture fee. However, all the inconvenience, and I don't know if this was even necessary to win, I don't know how many people, 400 plus, and just to remind people of something that maybe some were aware of, some others were not aware. I mean, that's not up to me to decide, but I was aware, right? And I'm being cited directly on something that I already signed, and it is my responsibility.
Let me, if I may, I'll answer that. okay? Nobody's citing.
I have the letter right here.
Okay, well, hold on one second. Hold on one second, June. I'm
Okay,
answering this gentleman, okay?
okay.
Nobody's citing you for anything, sir. Nobody's accusing you or blaming you for anything whatsoever. And what you have to understand is that the reason for the lawsuit is because title companies were not picking up the obligation for the recapture fee in their title searches. We had to come up with a methodology to make sure that the chain of title, the record of the property, reflected the fact that these recapture fees are there. That's why this methodology was used. Other methodologies were attempted by prior counsel. They didn't show up in the chain of title. We researched this roundly, trying to find a better, less onerous way. Believe me, nobody's accusing you of not being willing to do what you agreed to do. We have to do this in order to make sure that those people who go to sell and the purchaser's title company doesn't pick it up as it presently exists will have notice going forward. And it's necessary for the continuation of affordable housing programs. It's not personal. Nobody's coming after you. Nobody's seeking anything personal from you.
And I understand. I understand that part. I mean, I understand, and like I'm actually very grateful for the opportunity I had right out of school to be able to buy an affordable housing unit. So I'm not contesting that, and I hope that the future of the program is positive. However, like for example, today we receive a letter from the association, right? Where I mean, it seems like there were other viable options to have corrected the situation, specifically filing a non-recourse lien as said in the resolve restriction, right? And as a matter of fact, I believe that the letter some people were referring from the association itself, right? And they were demanding the HHC directly to dismiss the lawsuit. So I don't know exactly how.
Well, the only thing I can tell you is this: if somebody is making a demand that the case be dismissed, and they have a basis for their demand, it should have been forwarded to me as counsel for the BHHC for me to disseminate to my client. I have not seen anything like that. When I get it, I'll be happy to respond to it.
Okay. So now my question is, given so like if I'm not fighting the recapture fee, right? But at the same time, I'm not agreeing with the way all this was done. Not only because, I mean, I've been trying to learn as much as possible, but I'm also asking questions for a lot of my neighbors who may not have the same representation or the same resources that I'm fortunate to at least have, and I mean, I'm speaking for myself here, but the last 2 weeks have been very, very stressful just because of this issue, on top of, being a very stressful year, being, that everyone has been served in Christmas, New Year, almost also the way it was done, almost giving people no time to even react, right? Everything was closed. So getting in contact, as a matter of fact, I directly called your office, and every time I was getting forwarded to a recording. So it was almost impossible to get information.
You called my office? You called my office?
Yeah, and I was forwarded to a recording.
Right. And
yes,
what we did was we recorded a response to people, which is similar to what I'm telling you now. I can't give you legal advice. I can explain to you why we did what we did, what our intention was. I can't give you legal advice as to whether you need to answer, you can sign a stipulation, you don't sign it. That's not for me to say. You're not my client, and it would be wrong for me to tell you that. So that message was prepared and left there so that folks like you who called could get the information as best we could explain it in a message and be told to contact your own attorney or contact legal services if you couldn't afford one.
Yeah, but that's one of the reasons of my questions, like that, for not doing it, like nothing, like not having any fault at all. Now I'm being put on having to spend money to to hire a lawyer, to retain an attorney, or even to have some questions answered, right? And as a matter of fact, I'd like, if you or anyone can help me answer 3 specific questions that I have. One is, what are the possible future ramifications of this, right? If I'm buying a new house, will this affect me at closing? Is this going to be on my public records? If I decide not to respond because I agree with the recapture fee, right? Does this mean that I'm going to have in my record civil action lawsuit that I lost for no reason? Is this going to affect me future job applications? Things of that nature that I'm having a real hard time answering unless I spend $1,000 retaining an attorney or plus, So that's one. The other one, right? I understand you're saying the BHHC is not trying to, they're not litigating for money. However, based on what I'm reading here on the summons, it says that if we don't respond within 35 days, we could be liable even for legal charges. So let's say nobody responds let's say people don't respond because they agree with the fee, and then the HHC wins the case. What's stopping them from putting all the legal fees in all the owners of the houses? Legally, nothing is stopping them from. Is it?
Harry, I think you can answer that.
You raised a bunch of issues, and I'll preface my statements that my day job is a commercial litigator. Okay, this is what I do for a living. I, like Mr. DeFazio, cannot and do not provide any legal advice here, and everything I state is with that premise. That being said, I will tell you a couple of things that I know to be true. Summons is a form document that the court says you shall serve this with your complaint, and it's a form document. So that language you're reading, yes, it's in there, but what you should govern yourself by is what is asked in the complaint. There's a document called a complaint for declaratory judgment. And at the end of that, you'll see something called like a wherefore clause. That's the prayer for relief. Nowhere in there did I read, I did check this, I didn't see anything about, thank you, I didn't see anything in there about legal fees. And I will tell you that of all the complaints that I file on behalf of my clients in my private practice, every single complaint says, and legal fees, and such further relief that the court deems just and necessary or just and proper. It doesn't say that here. There is no request for legal fees. In fact, my experience is that if the court decided that the BHHC wanted to change its position 2, 3, 5, 6 months down the line to ask for legal fees, the court is going to direct the BHHC to go back out and renotice everybody because it's changing the way of the purpose of the lawsuit. You've been served with a lawsuit. The lawsuit asks for X, Y, or Z, and that's it. Okay, that's what's there. If the BHHC was going to change that and ask for something in addition to what you've already been noticed of, they have to renotice. Mm-hmm. You have to renotice you. You will not. That will not happen without you getting noticed again. Now, the difference between signing the stipulation and sending it back and not doing anything is essentially, do you want to get notice of what's going on? That would be the purpose behind entering into the stipulation that Mr. DeFazio is put together here. It basically says, I received it, I'm not testing it, but I'd like to get notice of what's happening. So can you serve me with the judgment, or can you serve me with the order? If you don't answer at all, what we do in our field, we enter what's called a default. We enter default against a non-responding defendant. The only thing that means is that you don't have the right to come in and object to something down the line without first asking to get into the case. That's really it. And you're not going to get notice of the.
And I understand that. And getting some of this information has been really hard in the past couple of weeks. And again, the ramifications, like, how is this going to affect us? Like, for example, if I'm buying a new home, right? Could this jeopardize my ability to get the new home, because now I have a lease pendants on this house that usually comes up when houses are being foreclosed, or even when selling. Could this start bringing down prices in the whole city, because now all these houses are going to have lease pendants? As a matter of fact, the lease pendency, yes. I mean, and if there is a civil action, litigation against my name, not only the lease pendency against the properties, but also civil action being taken for all the unit owners. And my guess is that that's going to eventually come up on public records as well as yeah.
Sir, look, we went through this earlier, but let me say it again because there was a point that I wanted to make there too. And forgive me for geeking out and getting all legal here, but what we call this type of proceeding in the law is called an in rem proceeding. In rem, what does that mean? It means it relates to this property only, okay? So I do a lot of foreclosure work, commercial foreclosures. My case is in rem, okay? My case only is related to that block and lot, okay? That meets and bounds description of a piece of property. But in connection with my foreclosure work, if the person that I'm foreclosing owes money to someone else and they have a judgment, I bring them into the case because I'm saying my rights under the mortgage are superior to yours. So you're bringing in these other parties sort of the same way that what's going on here. The BHHC is reaching out and grabbing you and bringing you in. It's to provide you with notice, okay? It's to provide you with an opportunity to be heard. That's it. Anyone who's worth anything performing a title search against you for legitimate business purposes and says, hey, Mr. Smith, I see a complaint here in a lis pendens. You just say that it has to do with a title issue affecting my neighborhood, and it applies to my next door neighbor and the person down the road. It is not the difference of an in rem personam. I'm coming after you as a person. I'm coming after you for your money. This is not.
May I interrupt you for a question?
Once again, it shows up as a lien, which is never good on your credit.
It is a lien insofar as it's providing notice. It is not
a financial institution will see it as a lien, and they see it as a negative thing. They don't see it as a good thing, right?
And to refinance, we now have to pay $175. So you're acting like this lien doesn't affect people, and it does.
Apples and oranges. You're mixing apples and oranges. The $175 fee is payable to CGP&H for its services to get you through your refinance while you're part of this regulated.
Well, I refinanced with the old association, and I never had to
benefit of other
anything.
Complete our answers, please. For the benefit of everybody, questions are asked, let the answers be given, else we'll have bad information, I'm sure, coming out of this. The stipulation and the subordination that Mr. DeFazio was describing earlier has nothing to do with $175 or CGP&H. Those are two separate things. The subordination that Mr. DeFazio has offered up is saying, hey, folks, if my lawsuit on behalf of BHHC is getting in your way, please reach out to me and I'll give you a subordination so that I'm not in your way. The CGP&H subordination is part of a regulated industry, folks. Banking is not the wild, wild west, and certainly not within affordable housing, okay? Boxes need to be checked, disclosures need to be provided so that when auditors come in to the folks like CGP&H, they don't get in trouble. That's what's going on here.
So Heather, I know we talked about this earlier, but if you can explain why refinancings are supposed to go through the administrative agent and just exactly what that process involves from your end.
Excuse me, I'm sorry, before we get off track, I hope you don't mind because I do have another question that I haven't been able to find an answer anywhere. The wording in the declaratory judgment says that the recapture fee should be paid to BHAC or its successor. Now, who will be its successor here? Because it is my understanding that the new administrator is not the successor. So if now that we have a new administrator, taking care of the program, right? Who are we supposed to pay? Like, are we supposed to be paying the city? Are we supposed to be paying BHAC? No. What stops? Who is the successor?
You're paying. The money that's generated from the recapture fees goes to the affordable housing program. Does not come to the township of Bedminster. It should be paid to CGP&H on behalf of Bedminster's affordable housing program to continue its life into the future. Okay, this is its lifeblood. So what BHHC is doing is essentially wrapping up affairs and making sure that going forward, there is certainty. People can search the records, see the obligation, satisfy the obligation, and free the unit up for the market. Don't forget, folks, and we're all in this together.
So wait,
This
sorry.
is
So
time
are you saying that the 20% is paid to the CGP&H, the new company?
No, and this is Mayor. So let me, let me put a little nuance
I'm
on.
sorry, I need clarification on this because this doesn't make sense. You said before we used to have to pay to the BHHC.
The calculation of the recapture fee. So see, Heather's office will figure out the recapture fee for a typical transaction. For your transaction or anyone else's transaction, they'll go to CGP&H to figure out what exactly that recapture fee will be. CGP&H will collect the recapture fee for the affordable housing program. The actual check that CGP&H is going to collect is going to be made out to the Bedminster Affordable Housing Program. CGP&H will collect that. The money goes to the Affordable Housing Program, Bedminster Township.
Mr. Mayor, I have a question.
And will paying the recapture fee automatically satisfy these conditions put in place by Bedminster Hills Housing Corporation, specifically BHAC?
This only works if we have order here, okay? If someone's speaking, please do not speak on top. We will try to get to everybody, but it's of no use to anyone to talk on top of each other, please.
So Nelson asked a question, then someone else had joined in. The process for the payment of the recapture fee, CGP&H will calculate that recapture fee when a unit is going to be sold. If it's in the restriction period, you'll be going through CGP&H anyway to make sure that you're selling to a qualified purchaser. If your unit is no longer restricted and you're going through your first market sale, then your title company or your lawyer will go to CGP&H and ask them to calculate the recapture fee. The recapture fee will be paid at closing. CGP&H will collect it. Once again, that check should be made payable to the Bedminster Affordable Housing Program as collected by CGP&H as the administrative agent. So your check does not get made out to CGP&H. They will collect the check and revert it back to the township where it gets deposited in the Affordable Housing Trust Fund. And I've laid this out on the letter that's on the website. The collected fees do not go to the township general revenues. They do not offset taxes. They do not go to special projects. They go back to the Affordable Housing Trust Fund to either pay for certain improvements, to pay for the administration of the Affordable Housing Program, to pay for rehabilitations, to be paid consistent with a spending plan that CGP&H and the Bedminster Affordable Housing Advisory Committee are going to develop. So they will develop a spending plan for all these collected fees and the existing funds that are still sitting in the Affordable Housing Program to be, as we talked about earlier, to be redistributed and to ensure the long-term viability of affordable housing here in Bedminster. So Nelson, I know that's a long answer, but when you run through your closing, CGP&H will collect that payment for the Bedminster Affordable Housing Program. Okay, so now Ms. Sullivan has muted everyone. So if there are questions, you can go to the bottom of the Zoom screen and wave your hand, or under reactions, or if you are on a telephone, you can hit, was it *9? *9. And Judy, if you could unmute Ms. Mahali and Mr. DeFazio. There's Heather, right? Was that her? Okay, so make sure that Heather and Sal are unmuted, and then run through who's ever got hands up. And
How do you know if their hands are up? Okay.
Calling on, first, Liz A. Okay, I'm calling on Liz A. I'm asking you to unmute. I need your name and address.
916 Timberbrook Drive.
And your name?
Elizabeth Alexander.
Thank you.
Okay, so earlier, Salvatore DeFazio said that if we do nothing, nothing's going to happen to us. But in the letter, it states, if you do not file and serve a written answer or motion within 35 days, the court may enter a judgment against you for the relief plaintiff demands plus interest and costs of suit. If judgment is entered against you, the sheriff may seize your money, wages, or property to pay all or part of the judgment. It doesn't sound like nothing will happen if we don't do anything.
so that's a question for Sal. So Judy, if you can find Sal on the list.
Sal is unmuted.
Sal.
I did unmute him.
Okay. I'm unmuted now.
Sal, you are on.
Okay. I didn't say that nothing would happen. What I said was you should feel free to confer with your own counsel. We've had lengthy conversations today about what the goal of the BHHC and the affordable housing program agencies trying to make sure that affordable housing has continuity in Bedminster is all about. The lawsuit seeks a declaration that the recapture fees are due from you. It seeks nothing else from you. As Mr. Stevenson very aptly suggested, this is an in rem complaint. It goes to the property. We are not seeking any damages from you. And if you look at the complaint that was filed, what we call the ad hominem, where it asks for the relief, we don't ask for any damages of any kind, not attorney's fees, costs, anything. We are only seeking a declaratory judgment that the recapture fees are binding.
So all we have to do, so what you're saying is that we have to sign this thing saying that we received it, that we're acknowledging that we received this and we agree to pay the recapture fees and then we
No, I'm not saying that you have to do anything. I'm saying that you should get whatever legal counsel you feel is appropriate. And if you discuss that stipulation with them, they may say to you, from their perspective as your counsel, understanding what this is about, I would do A, B, or C. But I can't give you that advice. And I apologize, Liz. I'm not trying to be rude here. I can't do that.
Well, if we understand that we have to pay the recapture fee, what is the best choice, or what is the choice that we have? What are the choices that we have again?
So Liz, this is the mayor. This is Mayor Jacobs. So once again, on the town website, I posted a letter. Judy, if you could.
It's up.
I have that letter. Yep.
So in that letter, there's essentially three options. You can fight it, and you could either fight it on your own, or you could hire a lawyer or go through legal aid to fight the recapture fee obligation. You could do nothing. You could just remain silent. Maybe a default judgment is entered, maybe not. The other option is that there's a stipulation on the town website, and if you agree that that's the master deed says what it says, and you're ready to say, okay, I want to know what's going to go on further with this litigation and I want to be on notice, you can sign that stipulation. You can either return it directly to Mr. DeFazio or Judy and Sal. I guess they could drop it off here and you can deliver it to Sal. And that would put you in queue to continue to get information regarding the lawsuit. But it would go on record saying that you agree that the master deed language is in there and that you consent to be, it's putting, you agree that the language is in there and that it should be of record on your title.
Let me just add to that. If that is the choice that somebody makes, Mayor, they can sign it, scan it, take a photo of it, email it to me and Judy, and then they can mail the original after that. There's no reason for them to come to town hall. In these COVID times, the courts are acknowledging scanned, signed documents. But I would like the original ultimately, but it can be sent by mail. Doesn't have to be hand delivered.
And Liz, I just as Sal has pointed out, I'm a lawyer as well. I don't do foreclosures or anything like this, which is why I brought Committeeman Stevenson to work, and be participating in this. Look, if people want to fight this, what we're doing from the township is that this issue poses a significant financial impact on the affordable housing program. And the fact that transactions were happening and the fee was not being collected is a problem. It's a problem for the affordable housing program. So the purpose of the litigation is to put on record that when a transaction happens, someone should go to CGP&H, or if it was last year, it would have been BHHC, and they would have figured out the recapture fee. A lot of folks have done that. I believe that there are a couple title companies that actually are sitting on recapture fees that may be held in escrow pending certain resolutions, and that may be the resolution of this declaratory judgment.
Okay, but if we chose to ignore it, are we susceptible to the court fees?
No, there's like,
And that's Committeeman Stevenson saying that, so I just want to.
I'm sorry, there is nothing monetary in this complaint other than when you sell, the recapture fee applies. That's the only monetary part of this. There's nothing.
That's fine that you say that, but that's not what the letter says. The letter says that if we don't do anything, that we are subject to the costs of suit.
You're referring to the summons?
Yes.
Yeah, again, it's a form document. That summons gets served, whether it's a declaratory judgment action or it's not. It's designed to light a fire under folks, which I think it's succeeded with here.
Is that language required by the courts?
Yeah, it's a document that is a exhibit in the appendix in the courts. It's
okay.
A court.
It's a form document, Mayor, and we are not going to seek costs from any resident. That's not.
Can we have a letter saying that?
Yeah, listen, I have no problem. I will talk to the mayor about adding something on the website about anybody.
Saying everything that you said tonight, maybe putting that down in writing. So make
I hear you. And I will talk to the mayor, and perhaps we should add something to the website that would resolve that issue for you. I hear you.
Sure. Because we hear what you're saying tonight in verbally, but that's not what's written in black and white. I think that's why people are getting so upset.
Well, the problem, Liz, is you're picking that up off a form summons document, not from my complaint. But we will address this. I heard it, and I already have a note to myself to address this based on prior conversation.
Good.
It's a great point. It's one that it's belt and suspenders. We'll do that. But just for everybody out there, it's not a request that I saw in the complaint for attorney's fees, and you're hearing from the attorney that's not what is being sought here. So if that's a concern, it should no longer be a concern.
Yeah, that would be great to have it in writing. Thank you.
Mayor, I think we should add that to the website. I can put something together that a stipulation that we could put in the website that we are not seeking legal fees or costs from anyone who agrees with the litigation or defaults on the litigation. We're not seeking that from them.
Liz, thank you very much for that question.
Good question, Liz. Thank you.
Thank you.
I'm going right down. The next person on here is Frank's iPhone. I don't know who that is.
Yeah, hi. This is Frank. I'm on Mountain Court in Village Green. Gentlemen, thanks for taking my questions. I appreciate it. I have a question and then a sort of a statement followed by another question. You keep repeating the fact that the only thing that's being that you're seeking here is the confirmation of the recapture fee. But 13B makes me awfully uncomfortable because it says that this court awards such additional relief as the court deems equitable and just. That seems to me to be frighteningly open-ended in that what's preventing the court from deciding, and I mean, everything's possible in the world these days, that, all you residents need to kick in a certain amount of money to make up for our loss. And would you be willing to clarify what Sal just said about that issue on item 13B?
Frank, Mayor, I think I can answer that. The stipulation will clarify that, Frank. We'll make sure that it's clear that the court is not going to award any kind of fees or costs against you that we don't ask for. That doesn't happen. Trust me. The truth of the matter is that you've got to fight for them when you're entitled to them. That's not going to happen, but we will, in that stipulation, we will stipulate on the record that we are not seeking costs or fees or any other form of payment from any of the defendants.
Understood, Sal. Okay. Next thing, I want to say that, I don't think I understand the need for it based on what you explained, Sal, previously, is that there were holes and you need to patch the holes. But I think, that the way you guys went about it, sort of scared the hell out of a lot of people here unnecessarily. Good people who were certainly willing to say, hey, I signed the deed. And if the recapture fee was in there, it's a non-issue. Of course, I'll pay that back. But my question is who, if you can say, who really dropped the ball in capturing, in making sure that these recapture fees were paid? It's certainly not the residents. Half of them don't even read their homeowners insurance policy. So was it the BHHC? Was it the lawyers and title insurance companies and bankers that were involved? It just smells real dirty to me. And why aren't they being held accountable? Where are the ramifications?
Frank, this is Mayor Jacobs. I love your question. And the answer to what you just said, from my position, is yes.
Okay. Fair enough.
Yes.
I understand. Okay. Thank you, gentlemen. I appreciate your time.
I appreciate that question. Thank you very much.
Bye-bye.
Okay, the next person coming down is someone named Shannon. Address. I need your name and address.
Hi, yes, Shannon, 606 Timberbrook Drive. My question is similar to what's been brought up before. The gentleman who was speaking a little while ago mentioned how something like this, even if we agree to it or, knew that there was a recapture fee, how something like this might impact us in the future. And Mr. DeFazio responded to Liz saying that he would post some sort of letter saying, something about the fees. And I think earlier it was mentioned, like if we do go to buy another property and there's a question, we can have someone contact Mr. DeFazio, but can there be something that's just given to us saying that this was not anything of our fault? And, just so that we don't have to try to track down Mr. DeFazio in the future if something does come up, say 5 years from now, someone Googles us and this comes up and, there's a question and I have to try to explain it.
So, may I answer that, Mayor?
Sal, it's the mayor. If I could just sort of maybe reform or put my little spin on that question is, so the pending action is for a declaratory judgment. What happens when the court renders a final decision, right? I imagine the court is eventually going to say, yep, the recapture fee provision in the master deed it survives the restriction period, and it is an obligation that exists at the first market sale. Or they say no, it doesn't. But anyway, there's going to be a resolution. Does that final resolution supplant what's already in place now? The filings that you've already made?
Are you asking me?
Oh, Sally? Oh, no, you're not. Okay.
Mayor, were you posing that question to me?
Yes.
Yeah, at the end of the day, Shannon, there's going to be a judgment. That judgment will be clear on its face as to what it entails. It doesn't entail you owing any money to anybody. It doesn't entail you're having defaulted on any obligation to anybody. It will simply entail the obligation to pay recapture fees on the sale of your unit up to the first sale after restrictions are lifted. When a title company goes to search your title, they will see that. They will see what it's about. It's not about you having an outstanding debt. But, you know, again, I've got to be a little careful here. I don't want to give you legal advice. Feel free to speak to your own attorney if you wish to confirm that. But this judgment is not going to be a judgment for money damages that you've got to resolve in order to go forward with your refinance or purchase or sale or whatever.
I think that's well said, and then stated another way, it's a case that's designed to address a gap in the land records, really, is what it comes down to.
That's
so
all it is.
When you go to sell your unit, your purchaser is going to hire a title company, and the title company is going to insure the purchaser's title. I mean, that's what you do. And all this is seeking is to make sure that when they search the title on your particular unit, they say, oh, okay, there's a recapture fee due. And then the title company will put a schedule together, and they'll say all the reasons why they aren't going to insure your title. And then there'll be, because you have to pay a recapture fee. And then you go to the closing, and then the payment made, and then all those things get resolved.
But Doug, and for Doug and Sal, Shannon's question is a little bit different. Shannon's question is, hey, is it, what's going to be in place if 5 years I'm applying for a loan or something? Whatever documents have been filed now will be replaced by a final judgment.
Right.
And that judgment is not going to, say Shannon's a bad person or Shannon's a good person. All it's going to say is that the recapture fee obligation exists. The recapture fee obligation exists now. But since it's in the master deed and no one is going through the administrative agent on their transactions, no one's really paying attention to it. So it's to bring it back to full attention. But to Shannon's question, what will ultimately be on record? It won't be the list pendants that's there today.
Right. So a searcher goes out, Shannon, to your place today and does a search of your records, and they see this document called Liz Pendants. And that Liz Pendants is notice to the world that there's a lawsuit out there. The Liz Pendants will refer the folks to this particular lawsuit. And the whole point of that, again, is to provide notice to the public. If you're going to take an interest in my property, be advised that this is going on. That when the case is over and the judge renders a final decision that either the recapture fee is owing or it's not, or whatever the court decides, it will be entitled a final judgment, a declaratory judgment or a declaratory relief. And it will say, it's hereby ordered that the following is, the way that this is going to happen. That document would then get indexed across all of the blocks and lots of the folks that have received notice of the lawsuit, such that someone down the line wants to buy your unit, they do the search, now they see the notation in the land record, aha, I've got to look at that. And now they know about this final recapture fee. That's the whole point of this, is getting notice to the public who are searching the records that this fee that's embedded in these 1980s documents is out there, it's alive and kicking. And by the way, we're sort of the first to go through this. We said this before. That's why it's so critically important, because it had been missed. And you could assign blame one way or the other, whatever. It is the reality in which we have, in which we're living in. So the idea of the STIP was, again, to realize and recognize the fact that no one here has done anything wrong in terms of the defendant pool. You've been named simply because you own a unit in an affordable housing program that needs to get the land records straight as we go through this.
Shannon, I know you got a lot of answers from 3 different folks. Are we hitting your question?
Apparently she's muted.
Oh.
I think you muted again.
I think you're mute again. There you go.
There you are.
Yes, that does answer my question. I mean, my question not only had to do with buying and reselling, but even, trying to get a new job if that comes up, or just anything that, being named in a lawsuit where you really had nothing to do with it, except the fact that you're the homeowner and there was an issue prior to you owning the home. That's just my only concern, like how I could prove to someone if I ever had to. I don't know.
The best thing you could do is keep a copy of the complaint in your nightstand drawer. I know it'll be great nighttime reading, right? So just keep it. It spells out exactly what this case is all about.
And then the case will be resolved.
Yeah, and
hopefully the case is resolved in a few mons.
Yeah, exactly. This is our hope and desire is that this is not lingering into 2021. That everyone gets served. This is hopefully the hardest part, is rounding up all interested parties and getting them before the court and satisfying the judge that, yes, I've gotten all interested parties here on notice of what's going on. Who's filed a contesting answer? Who hasn't? Let's have it out, and then there's a decision. And that's it. And that's the case. I mean, and whether it's good or bad, we all live with what the judge decides.
So, Shannon, thank you. Thank you for the question.
Yep. Thank you for the detailed response. Thank you for your time.
Okay, thank you. Now, there's something that was raised before that I think there was a lot of folks talking over each other, which is, was there a better way of doing this? Was there a better way than having BHHC serve everyone who has a master deed that has that language? Was there a better way? So the question had been posed to Sal DeFazio, and by the way, the township looked at this issue as well. And was there a way? How do you do this? And the response back, and Doug had made reference to another court decision, because the language that's in play right now is in the master deed. It's in the master deed for Parkside. It's in the master deed for Cortland. It's in the master deed for Village Green. It's in the master deed. Well, I'm calling it the master deed, but it's the deed of covenants for the units in Timberbrook that are also restricted. So that same language drafted by the same law firm 35 years ago, 30 years ago, it applies to all those same units. So if there's going to be an interpretation of what that language means, and Sal DeFazio can cut me off if I'm heading down a wrong legal theory here, but because everyone is subject to that same language, if there's going to be interpretation of that language, you've got to give everyone who has that language in their deeds, in their covenants, the opportunity to say, I agree or I disagree. And the only way to do that, unfortunately, is the action that Sal DeFazio initiated.
I can actually add to that, Mayor. In prior litigation, unrelated to you, Shannon, or anybody on this call, for the most part, not anybody, but people who we've served with this complaint and this action, the court already has said that the recapture fees constitute a valid lien. The problem is not whether it's a valid lien. The problem is it's not being picked up on title searches. So I fully expect that the lien will be determined to be valid as it was before. The judgment will be entered. It will be on record, and it will be something that title companies will pick up. And that is the focus of what we're doing. It's an aggravating process because there's so many defendants that have to be served. It's cumbersome, and we apologize for that. Nobody wanted anybody to be upset by it, but it's what we have to do. If there were another way, trust me, all of the legal minds that got together to try and figure it out would have come up with it.
Judy, if you want to continue.
Okay, the next person is Kay Bouters. I'm saying that correctly?
It's close enough.
Hi.
Hi, am I on?
You are on. Name and address, please.
Give your name and address.
Yeah, Kristen Bouters, 44 Village Green Road. So Mayor and Doug, also thanks for doing this. This is very, very helpful. I think though my questions are really going to be addressed to Heather, and it is in regard to the end of the restriction. So one, at the end of the restriction, or can we be given some kind of a notification when the end of our individual restrictions are? A. B, I'm a little funny about the major capital improvements and the fact that they cannot be deducted from a resale or recapture fee. Carpeting is one thing, flooring is one thing, but when you have moved into a unit that needed an entirely new bathroom, an entirely new kitchen and windows that we have spent all of our money on, be it during a restricted deed or after a restricted deed, if we have no recompensance for declaring those items, what is the incentive to stay in the affordable housing program? And let me state clearly, I believe in the affordable housing program 100%. It is valuable. I have no problem with recapture fees, but what do we do about $20,000 sunk into a unit when you can only resell it for 10 grand more than you bought it for?
So, Kristen, this is Mayor. Before Heather goes, so are you talking about selling a unit while it's in restriction?
Well, of course, this is the debate that you have with yourself, because does it pay to stay in the program? That's my point. Is there any incentive to stay in the program, or is it better to pay the 20% recapture after the program, which is kind of a face slap to Bedminster, who has administered this program for so long and pretty diligently. So,
Kristen, you have a great policy question, and Heather Mahali is the right person to answer that.
I think so.
Let me just start by saying, can you hear me?
I can hear you clear as day.
Okay, good. Let me just start by saying Bedminster is different than most municipalities in this way, in that, and because it was done before COA, before there were more statewide rules that showed municipalities how to do this, Bedminster put in this 20% recapture, and it also put in the improvements. This was done in the public offering statement from back in the 80s. So generally what happens when you have affordable housing is that there isn't any consideration for improvements in an affordable unit that's being sold to the next affordable homeowner. And because these units have to stay affordable in order for them to be effective. So we're getting our heads around this because we don't generally allow for improvements. The only time you would ever see money added to anything for an improvement is if you made your unit bigger, and it could hold a bigger household, meaning that you could increase the income limit of the household going in there, meaning you can increase the price. So prefacing this by saying that generally improvements are not considered. So, and like I said too, we are trying to understand this. But I mean, does that kind of help you? If we gave consideration for improvements that were, you know, for a new kitchen, that could be $20,000-$30,000. We'd either price the unit out of affordability, or, and the other way, I'm not sure how that would even work. You know, so what we're doing is we are trying to balance it, giving consideration for things that do wear and tear, the carpet, the floors, washers and dryers, and things like that. Those things do need to be updated every once in a while, and you will see consideration for having done that. But for things like putting in a new bathroom, I understand, you know, you want to live in a place that you enjoy. And this is the discussion that we have with most of our homeowners who ask us about doing upgrades in their home. We say, if you're going to enjoy it and it's something that you want to see in your home, then we, you know, by all means, go ahead and do it. You're not going to see an increase in your home value because of those. But what you might see, and what you likely will see, is when you do sell it, you're going to sell faster than other people who have not upgraded those things. So we do have, you know, where in most of our cases where people don't get any consideration for upgrades, people do upgrade because they want to enjoy their home. And then they do see a faster sales process. We just took basically what BHHC had been doing. So we are not making any changes, I don't think, to what Sharon had been giving improvement credit for.
So Heather, it's the mayor. So coming back to Kristen's question, I guess there's two issues. One is determining the resale price while the unit is still in restriction, right? So that's dictated by the COA and the UHAC rules, right? So you can, if you paid X for it, you've owned it for certain years, you calculate the resale value. There is credit given under the Bedminster program, just as Heather alluded to, that the Bedminster program does provide credit on the recapture fee calculation. So while those improvements may not factor into your resale price, they are factored into the recapture fee obligation, and they come off the basis with some depreciation, and the depreciation is something that BHHC had instituted years ago. And I believe it's actually in the master deed language itself. So, but once your unit comes off restriction, then you're not going to Heather to determine what your resale price is. Then you're at market.
Right.
You're whatever the market will sell. So in Timberbrook, you may be coming up on end of the, well, if you just bought, you may have been extended, but a lot of units in Timberbrook are coming out, I would say 2025 or something along those lines. And then you'll, at that point, if you're off restriction, you will not go to CGP&H or whoever the administrative agent is to figure out your resale price. Your resale price will be market driven. But you will still get credit on the recapture fee. And that is something that CGP&H will calculate at that time.
Yes.
Okay, so recapture fee, major capital improvements could potentially be deducted from a recapture fee.
And I believe this is what Sharon did as well. So again, we are doing basically what BHHC had been doing before. The improvements that I put on the slide, those are for affordable to affordable. So if you're selling it as an affordable unit, then those would be the improvements that we would take into consideration when calculating your recapture fee. She would give more consideration to larger capital improvements when it was being sold at market rate. And we would continue that.
Okay, so one last question, and I thank you for indulging me. Will you, Heather, and your company, will you send all of us or will somebody, the town, send us a date that we are off restriction?
I'll have to consult with the town on that. I need to consult with the town legally on what that date is specifically anyway, whether we can share that with everyone. I'll have to find out about that. What we will be doing though is sending everybody a mailing every year to remind you of who we are, of what we do, and that kind of thing. So we will be touching base with everyone annually to, even if everything's fine and don't need to do anything, we will reach out to everyone.
That sounds great, Heather. Thank you for your time. And again, it would be very nice to have a reiteration of who you are, how you represent us, and something via the mail so that we know how to, contact you for those of us who weren't on this meeting.
Absolutely.
All right. And thanks, Mayor, and thanks, Doug.
Thank you.
Well, anytime.
Okay, the next person on the list I have is someone named W-O-J-O, Wojo.
Hi, this is Andrew Wojciechowski at 20 Larkspur Court. Sal Mayor Jacobs, first, thank you for your time, specifically regurgitating the same answers to the recapture fee. A little change of direction here and a good follow-up to the question that was just asked. I'm not positive who would best be fit to answer this. Perhaps, Heather, this might be for you as well. I'm in Village Green. It's my understanding that each township has to have a defined number of affordable housing units, whether that's a concrete number or percentage, I'm not sure. When the deed restrictions expire, my understanding that Village Green is 2025. Correct me if I'm wrong there. Is it all units in Village Green? If yes, that's potentially a wonderful thing. If not, how is it determined what units are chosen for that? I mean, basically, am I sitting on a unit that in 5 years might be hitting full market value, which I recognize I have paid substantially less than market value upon?
Okay, so I will try to address that question. So this is, it's the mayor. So thank you, Mr.
Wojo's fine. There's too many letters in the last name.
Thank you, Mr. Wojo, and thank you for thank you for giving me Wojo. Deeds with the deed restrictions or the affordability restrictions were originally set for if you're in Village Green, that was a 40-year term. Village Green was the first development constructed, subject to a 40-year affordability restriction period. All the other neighborhoods that were constructed in Bedminster were subject to a 30-year restriction period. If there was no extensions, those units would, I don't have the date in front of me, I believe it's 2025. Yes. And I don't know the month. Those units would be, they would have their affordability restrictions expire at that time. Certain units, and this started, I believe, in 2007, that when BHHC was selling units, they would go to the sellers at the time and said, will you consent to sign an extension of those restrictions? So each unit may be subject to the original expiration date or may be subject to an extension. I believe the extensions were first put in place
2008.
in 2000, Ms. Sullivan is telling me 2008. So if you bought before 2008, your unit likely expires in 2025. If you bought after 2008, then it may be subject to an additional restriction. And that would be, that should have been recorded. It should have been recorded with your title work. And if you still have those original papers, you may want to pull them up or talk to your real estate attorney or your title company when you purchased, and they should be able to provide you those details. That is something I believe that CGP&H is trying to work through a lot of the BHHC records to get a better handle on that very issue.
Yes.
Heather, do you have any additional comments on that?
It is, you're right about the 40 years, and I believe that it is in 2025. What I'm trying to do is get that exact date, and that's, that'll be something that that we can certainly share once I know that, because it's not a secret.
So then in that breath, if certain units have filed extensions, is it possible in the exact month or year, just for argument's sake, call it 2025, under that umbrella, would it be possible that one unit is an affordable housing unit and, for lack of a better word, my neighbor would be a quote normal unit? Wouldn't that then potentially sway the market one way or the other?
What do you mean by sway the market?
Like if I have purchased my unit under the affordable housing umbrella, and just for argument's sake, say my unit's on the market for 140,000 under that same umbrella, and the unit next to me, well, theirs expired, and theirs is on the market for 240,000. Well, pending your financial situation, it's no secret which one's going to sell first.
Well, so the market rate unit, we don't have. Are you talking about like a market rate unit for 240?
I'm talking about if something was deed restricted versus not restricted, if extensions were filed versus not filed, potentially then a neighbor could be restricted and the unit right next door then could be normal, for lack of a better word.
Absolutely, yes. And the difference is going to be that market rate unit can be sold to anybody. Sure. So that's on the market, and they will get what they can for that, what the market will bear for that one. The affordable unit will be sold at an affordable price that's calculated, using an index that goes up every year or most years, and will be sold to someone who's on a waiting list, who is eligible for that unit. So it's kind of apples and oranges, those two scenarios. And the market shouldn't be affected by either one of those things, because they're going to be done with different clientele, shall we say.
And Heather, it's the mayor. I can, I guess it was over the last year, maybe 2 years, Sharon DeSico was reporting on primarily Parkside, and she was saying that there were units that were transacting Parkside. So to Rojo's question, there actually is already precedent for this. So you can look in up in Parkside, and to some extent, I'm not sure how many units have transacted in Cortland, but you would also have seen one unit that might be subject to extensions. Therefore, its resale is set by the affordability restrictions, and the purchasers have to be qualified under low or moderate requirements. So the universe of purchasers is limited, right? They've got to be qualified, and your resale price is limited under the affordability restrictions. But the next unit over may have come off restrictions and is selling at market, and they may be selling at 200 or 225 or 250, and the unit that's still in restriction may be at 140, 150. And both units are selling. They're selling to the population that's eligible to buy. In the case of market, it's anyone. In the case of the affordable units, it's the same. Bedminster, these types of affordable neighborhoods, these were units that were, so all of Parkside, when it was built, was restricted. Same with Cortland, same with Village Green. What you see today is a little bit different. You see what's called inclusionary development. That's where you might have one project and spread across that project could be 20% affordable units. So if it's in a condominium or an apartment building, one door might be restricted, the other door may not be. But they're still subject either to market constraints or the affordability constraints. So Rojo, I hope this somehow addresses your question. Does it sway the market one way or the other? Well, the one that's no longer restricted can sell for whatever the market will bear. And if it's the first transaction, there's the recapture fee. And if it's the second or third or fourth or fifth or sixth and the recapture fee's already been paid, then it's free and clear of the affordable housing program completely. If the other unit is still in restriction, then once again, both the purchase price and the universe of buyers is constrained by the affordability.
Understood. And you're saying to find if that extension would file, that would be something incumbent on each homeowner on their specific deed.
I didn't hear the question. Rojo, can you repeat that, please? I didn't get that.
I'm sorry. And then just to, you said if an extension had been filed on a unit, that's something that each homeowner would know under their specific deed.
Yes, they should know. They should know. Yes.
It should
and when
be,
you go to sell,
it should have been recorded in the land records, Mr. Wojo. It should be there in the land records so that it's searchable, so that the purchaser understands that you're either purchasing a restricted unit, it's subject to the qualifications, or it's a unit you're purchasing at market.
Understood. Thank you.
Thank you. Ms. Sullivan.
Okay, next I'm calling on Michelle Hoffman. She was on the top of the list, but she got booted out and she's back in now. So I'm going to click on Michelle Hoffman.
Hi, thank you. I have a couple of questions and I'm not sure who they're directed at. One, I want to know if the declaratory judgment will apply just to the affordable units or the market value units as well. So I guess maybe Sal knows the answer to that.
All of the residents of the affordable housing community are being served with the complaint. It will apply to the extent that a unit that is post restrictions has been sold and a recapture fee was not paid.
Okay, but how about units that are market value now and have not been sold? Will the declaratory judgment apply to them as well?
Of course, it will. They are in particular units that we're concerned about because we want to make sure that the duty of the owner to pay the recapture fee is set forth in the list pendens pending the judgment and then the judgment so that the recapture fee is paid.
Okay, and how will those people in the market value units be notified of the outcome of the declaratory judgment?
That depends upon the manner in which you go forward. If you retain counsel and file an answer, and you would be kept apprised of the developments by virtue of typical court communications. If you file the stipulation, you will be advised in accordance with the stipulation. If you don't answer at all, you won't be advised. You'll just know when the judgment arrives.
Okay. And will the Liz pendants impact anyone will deter people from trying to purchase here? Like if someone is trying to purchase, do you think that would deter them when it came up on a title search?
Well, you're asking me to speculate, okay? when somebody goes to purchase your unit, they're going to purchase your unit based upon their desire to live in that community at a price that they can afford to purchase it at, that they think is a reasonable deal, right? Like any other sale.
Okay.
When they start that process with a contract, they will then have a title search done. The title search will reveal that either the lis pendens, if it's before a judgment, or the judgment once it's entered and the lis pendens is no longer relevant, one of those two documents will reveal to that title company that the seller has to pay a recapture fee. It won't increase the price it won't cost anything to the purchaser. So on that basis, I'll let you reach your own conclusion about whether that would in any way dissuade them.
Okay. And also, Heather, I had emailed you a couple weeks ago looking for a copy of, or a list of the items that could be deducted as far as improvements. I haven't gotten that yet, so I'm hoping that can be posted somewhere and shared. And then my second part of that question is that you mentioned that the depreciation on the items of improvement, and that's on a recapture basis of being 10% per year. I don't find that anywhere in the master deed. So where is that dictated?
I honestly, I don't know. It's on the sheet that Sharon had given me. It's what Sharon had told me. And it also makes sense. You know, if you put in carpet 9 years ago, it's not worth what you paid for it at that point, especially if you have dogs and, you know, it's been trampled on. And
I'm thinking of more of the larger ticket items like new kitchens and bathrooms, and, you know, if people put in certain types of flooring.
I don't know. I have a feeling that it was probably discussed at probably a BHHC board meeting or something. I haven't gone through the full documentation, and I don't know.
Okay, but you said hello?
Hello?
Can you hear me?
Yes.
Okay.
Yeah, Heather's still there. This is Michelle, this is Larry. I will say, I once asked that question of Sharon at a meeting.
Okay.
And the answer I got was not from Sharon, but was from Ed Schmier. And Ed Schmier said, I did research and I looked into this issue and I came up with this calculation. And we've been, I'm not sure if he went to COA or DCA to get that 10% depreciation in place, but that was the answer that he did give, that it was something that he worked out after being directed by Sharon to look into a depreciation amount and a time period.
Okay, but where is that documented? Anywhere.
More information other than it's something that Sharon and Ed came up with. Whether, once again, if they went to DCA or COA for guidance on that, I don't know.
Okay, because again, it's not documented anywhere, so I think that people will challenge that. Also, I had a question. The master deed indicates that the BHHC was supposed to maintain the liens, and it seems that that's not the case. It seems that they never did that, and that's why we're in the situation we're in right now. Is that something that is part of the declaratory judgment?
Michelle, this is Doug. Are you asking whether the BHHC's obligation to maintain its lien on the units is part of the lawsuit?
Yes.
Yeah, I mean, I think that that's a fair characterization. As was said earlier, the lawsuit was started because units were transacting and final recapture fees were not being paid back to the program. So how does one prevent the problem from continuing?
Okay.
Fazio has stated that the rationale was to do a suit which the court, refused to hear because not everybody was before it. So the court said, please go back and give everyone notice of what you intend to do, what you're asking me as the judge to do. And that's just it. They're asking the judge to make a determination that the master deed provision says what it says, and that it is in fact an obligation that must be satisfied. I think practically speaking, what's going on here is that and this is pure speculation on my part, but it makes sense that as title companies were searching the records, they weren't mining down into the master deeds to see what this provision exists. So they're missing it, and these sales are going on. So that the point of the suit is to get a document in the land records that gives the world notice that there is this obligation, because it's sort of this, like we said, we're the sort of the first one out after 30 years. So yeah, I mean, I think that that's a fair characterization to say that the suit is intended to enforce or to maintain the liens on these units.
Okay, but there's no stipulation with the fact that the BHHC failed to do what they were required to do that would change this at all.
Let me answer that question, please, Doug. In the prior litigation that I was not part of, the court already determined that the master deed language of the covenants and restrictions creates a valid lien. Title companies were not recognizing that valid lien. Therefore, we have had to take these steps to ensure that the lien is recognized and honored.
Okay.
So Michelle, the answer is the covenants in the master deed are liens. They are considered liens, and the court has already ruled on that.
Okay, that I did not know. That was why I was asking.
Okay.
Okay, and then Sal, you had mentioned something when someone was concerned about the Liz pendants and how it would impact them. You said that they could receive, I guess, from your office or the town, subordination of the notice of the Liz pendants.
Yeah.
How long is that going to be needed?
Go ahead. Finish, Michelle.
Yeah.
I apologize.
How long is that going to be needed?
Well, the Liz pendants, essentially what the Liz pendants does is it notifies the world that the litigation is pending. That's what Liz pendants means. As soon as the judgment is entered and becomes a part of the record, the Liz pendants becomes moot and is dismissed.
Okay.
But it has to be there so that if tomorrow somebody who has been served with the Liz pendants and against whose home it applies goes out and tries to sell their property without paying a recapture fee, the title company that searches for the purchaser is going to see the Liz pendants. So it's the vehicle by which, in legal terms, we notify the world of the pendency of the litigation.
Okay. Okay. And then, yeah, so my last thing is, Heather, if you can somehow put together a list of the improvements that are considered, that would be great, because it seemed that whenever we asked Sharon, it was just something verbal. We never had something in writing. So it'd be good if that was on a website or accessible to homeowners.
Sure,
Might
we
help
can-
people
we can
decide
do
what to do. Yeah.
Yep, absolutely.
Okay. All right. Thank you for your time.
Thank you, Michelle.
Thank you.
Ms. Sullivan, and I do, Ms. Sullivan advised me that under our Zoom contract, we get 3 hours. And since we started at 5, we've got a half hour left. So let's keep going, but be mindful. And if there's still a whole lot of questions that are pending, and if we need to do this again, if that's what we need to do, then we'll do it again.
Okay, the next person is Miss Hart, Hartje.
Hi, Noelle Hartje, and I'm at 117 Cortland Lane.
Hi there.
Hi. So I have a few questions from people on Facebook that weren't able to get onto this meeting. So one is, so you say that it's the lifeblood of the program, these recapture fees, but where does the recapture fees go? And what is the spending plan? Will these funds be given to the 4 affordable housing communities for project upgrades? Like in Cortland, I just learned that their sprinklers, they haven't been turned on. We also need gutter improvements and other improvements. So where is this recapture fee going, and what's the spending plan for the lifeblood of the program?
Okay, so this is Mayor. I'm going to once again put the tap onto Heather. So there's an existing spending plan, and the spending plan is something that the township develops in concert with BHHC. The spending plan gets, we don't have our town attorney here. The spending plan then gets referred over to Fair Share Housing, which gives its consent or comments on the spending plan. The existing spending plan has provisions for foreclosure assistance, dues assistance, mortgage down payment assistance. In the past, BHHC has given grants to some of the communities. At the time they gave those grants, the communities were all subject to the affordability restrictions.
100%.
So 100% of all those units at the time that those grants were made to the associations were all subject to the affordability restrictions. So now I'm going to turn to Heather. And Heather, as we move forward and we fully anticipate taking another look at that spending plan, and from my perspective as mayor, it's one thing to accumulate the funds, but it's much more important to make sure those funds are deployed and deployed appropriately. So this is where really we tap the expertise of CGP&H. What are legitimate expenditures within the spending plan for those funds, and how are they allocated when you have units, for example, as is mentioned in Cortland, where you might have some units that are still in affordability restrictions and other units that are now market. So Heather, you got a tough one there. What do you got?
So the spending plan, yes, it directs all of those recapture fees go into the Housing Trust Fund, which is monitored by the township and also by Fair Share, who's looking at the overall plan for Bedminster. So that money is preserved for affordable housing. The spending plan has certain restrictions. So there are caps on what you can spend for, say, administration. So for our work, for attorney work, there's a cap of 20% that you could, of that spending plan, that you can spend on that. There's also a requirement that you spend 30% on affordability assistance. And that would be things like down payment assistance. And if you had rental units, first month's rent, or, you choose, the municipality chooses how it wishes to spend those affordability assistance funds. But those are spent for the affordable units to help eligible homeowners or renters. There's a requirement that some is spent for very low income. So, and what we anticipate doing with the township is those funds, those affordability assistance funds, putting a plan together. There's already some programs that are out there, but putting a plan together on how those are going to be spent, what the requirements are, making that very clear to everybody. There's also, a lot of the trust fund is supposed to be spent on housing activity. That can be on rehab. It can be spent on, capital improvements for, say, a condominium association. And like the mayor said, I know that had been done in the past. We would be constrained in maybe, say, Cortland. We could only spend funds on those what percentage of the units are deed restricted at that time. So some of the Cortland units have gone to market. We're not able to spend trust fund monies on improvements that would affect those units, or what we would have to do is, if they came to us for a plan, we could only spend a percentage, whatever that percentage of affordable units is, on those capital improvements. And I think that that's something that we will be working on in the near future.
And another element of the spending plan can be, and I'm going to really pose this question to Heather, is to induce unit owners to put restrictions on or to put their units back into the affordability program. So the spending plan, and once again, I believe this is subject to the COA or UHAC rules. Heather, do they allow those same funds to be redeployed? For example, if Ms. Bowders, who was on the phone before, hey, you know what? The affordable housing program will give you X dollars if you agree to put your unit back into restriction. Is that a viable expenditure under a typical spending plan?
Absolutely. It's called extension of controls, and we administer that in several municipalities. So yes, that is something that we could do.
And that is actually something that I intend on asking the newly formed Affordable Housing Advisory Committee to work with CGP&H and to actually look at that issue and offering financial incentives to induce units that either are about to go off restriction or maybe those units that have already come off restriction, to see if there's a process to get those units back into the affordability program.
So can I ask a question, Heather, on that? This is Doug Stevenson. Do you know whether the extension of controls process requires a recertification or requalification by the owner into the particular program?
It does not. That would be a municipal choice. We always think of it as, we don't recertify owners every year. People can be outside of the eligibility anytime that they're in their unit. We think of it as what you're doing is you're preserving that unit. It's not necessarily for that owner, but it's into the future for future owners. So while that is a possibility, if you don't do that, you'll get more units, basically.
And
Does that make sense?
Yeah, and this is, Doug, it's your question exactly, and I think that's something that will, when the Affordable Housing Advisory Committee meets with Heather, that's a question that we're going to put out there and say, look, make a recommendation back to the Township Committee. Do you want to offer these inducements? What range of inducements might be? What, could be 5,000, 10,000, 20,000, 30,000. And a recertification requirement, yes or no. What does the Affordable Housing Advisory Committee recommend back to the township? Then the township would work with CGP&H to formulate that back into the spending plan and then to put the spending plan in place. And then it would be up to CGP&H to go then market that program and let all the folks know that this opportunity arises. Hey, maybe you want to you're going to sorry if I'm choking over here. You're going to spend 10 more years in your unit before you sell it because you're not going to leave Bedminster. That's the type of people we like, right? You're not going to leave Bedminster. So for them, hey, sign on the dotted line and get some money to put my unit back into restriction. I'm not going to move anyway. I'll take the cash now rather than later. So that might be something, but we certainly want to hear that from the Affordable Housing Advisory Committee.
Also, can you confirm that there's currently over $2 million from that program in an account?
Judy, do you know what that exact number is?
The funds we've had returned, plus the township's funds. Close, approximately. I don't have a final tabulation.
Yeah, we're actually still getting the numbers, and we're still getting some of those accounts handed over from BHHC back to the Township's Affordable Housing Trust. So once again, that's something that the Affordable Housing Advisory Committee will then work on renewing or redoing the spending plan, and once again, having a new proposal to redeploy those funds. So Judy is still, I think there's still a couple checks you're waiting on from BHHC?
Yeah, we're still waiting for 2 checks, so
yeah.
I don't have all the totals.
Okay.
Our monthly fees keep increasing, and we're paying a sewer fee, which we shouldn't have to. Our monthly fee should be a little more than 100. We shouldn't be having to pay for sewer as well. And then another question, signing documentation for recapture as opposed to a lien.
I'm sorry, I didn't hear the question.
Why we can't sign documentation for recapture as opposed to a lien.
It's all about the issue being searchable into the future. It's the process by which one goes to identify issues in clouds or whatever the word you would use for, what exists on real estate. So that wouldn't be searchable so if there was just an agreement between the owner and the affordable housing.
Okay, is that it, Ms. Hardship?
Yes, at that time, yeah. Thank you.
Okay.
Thank you.
Thank you.
The next person on the list is identified as Shade, S-H-A-D-E.
Hi, good evening, everyone. Thank you for today's meeting. I do have some questions.
Could you give us your name and address?
Sure, it's Shade, 11 Larkspur Court.
Go ahead.
Thank you.
Hi there.
Hi, my first question is, as far as this document sent to Mr. DeFazio's office in regards to choosing to just, accept it, when is that due?
It's 35 days from the date that the person who served you with the papers gave it to you. So
I'm assuming everybody got it the same day, right?
No, unfortunately, because of the number of people that were serving Sade, the process is, believe it or not, still ongoing. Because some people aren't there the first day that the server gets there, or the second or the third. So not everyone was served the same day, but you should be guided by the date you were served.
Yeah, that's not really clear on my document that I'm reading right now. It says December 18, 2020 on the header, and it says Bedminster Hills Housing Corp. Versus Karen with a different last name.
Okay, Sade, if you call my office, we can look up the proof of service and let you know what that date was. But I can assure you of this, we are not going to seek default as against anybody until everybody has been served that we're trying to serve, and the 35 days runs as to them. So you have plenty of time.
Yeah, I definitely want to call you. I did reach out to your office and leave a voicemail for a callback, and I did not hear back from anybody because I do just want clarification as far as how much time I have as if I do choose to obtain an attorney.
If you give us your address, we'll be able to look up the proof of service and tell you when you were served.
Okay, awesome. And then my next question is, I understand that you answered this question a couple times, but I'm still looking for some clarification as far as, let's say an example, today I'm searching for a job or even searching for a new home. If someone looks me up, my name, is there a lien on my name?
You know, again, maybe the mayor or Mr. Stevenson can answer this. The problem I have with this, Sade, is I have to be very careful. I can't give you legal advice, as I've said many times before on this call. So my opinion is really irrelevant. You probably should confer with your own counsel or with Affordable Counsel if you have those concerns.
Doug, do you know, without giving legal advice, Doug, generally, DJ action that, as you said, is in rem.
So the way folks search the records, they would have to go into the court's website and run a search for your name, and then it would come back as a hit, and it would refer back to this particular case. There is no public record other than the complaint and the lis pendens that's recorded against each particular unit that broadcasts to the public at large that you're a named defendant in a lawsuit. The lawsuit is a matter of public record. So anyone could march down to the courthouse and ask to pull the court docket on this particular case and see what Mr. DeFazio has filed. We'll see what anybody else files in the official court record. But generally speaking, their ongoing active lawsuits do not give concern to people who are looking over records, because what they're trying to do is, as of the moment in time of today, for the purpose I'm looking for, whether I'm lending money to you or I'm taking a lien on your property or something that's very, very time sensitive, that's the only time where they're going to run down this kind of search. So I don't know what you mean by, is it a lien on my name?
Or judgment, anything like that.
In a lawsuit that it has to do with the declaratory judgment action along with the hundreds of other folks that are listed in a caption. Yes, so that does exist for sure. I'm having a hard time coming up with a scenario where that becomes problematic for the defendants, other than what we've talked about. Like if you're in the process right now in real time of refinancing or trying to sell, and now there's an issue, Mr. DeFazio has said, if you're in that situation where you are in the moment, so to speak, reach out for him and he will engage in your particular transaction to make sure that you can complete it and everybody's living happily ever after. So the idea here is not to cause mayhem. The idea is to form order and make sure that this program continues into the future, and that as we sell off units, as everyone's prospering, hopefully, and we're all making gains on sales, that the program is refunded as 20%.
Thank you. That kind of goes hand in hand with my next question, as far as I know that it was stated that you guys were going to have something on a website or just some type of something in writing of regarding this and how it would affect us or how it would not affect us, especially when it comes to not seeking anything monetary from the homeowners. So my question is, where exactly can we find that as far as the website, the exact web address, and also when can we expect that document to be written?
So if you take this down, it's www.bedminster.us. Okay, that'll take you to our homepage. From there, you'll see a tab for government. Click the tab for government, and then you'll see a sub-tab to affordable housing. If you then click onto the affordable housing, you'll see Mayor Jacobs's letter, and you'll also see the stipulation that Mr. DeFazio has agreed to enter into. Now, again, you only sign the stipulation if all of those statements on there apply to you. You purchased a unit as an affordable unit. You understand there's a recapture fee that when you sell it, you've been served with process, and you wish to basically step away, but you want notice of the decision. You sign that document and send it back to Mr. DeFazio, or are we saying town hall, or leave it here or no? Send it to Mr. DeFazio.
Put it here or send it. And as Sal said, they could fax it. Fax it. Don't fax it. Email it.
We'll scan it and get it.
The point is that once you sign that stipulation, folks, you're confirming to the court that, yes, Mr. DeFazio served me with his complaint. And I understand this is going on. I don't have an issue with it. Rule how you want to rule, Your Honor. The next thing you're going to see down the line at some point is a decision. And the decision replaces the notice of lis pendens. The notice of lis pendens will go away. okay? And the decision serves in its place. And that decision will go against all of the units for whatever however the court decides. But again, to reaffirm, there's nothing in the complaint that says plus legal fees, okay? So not an issue of.
But I believe Sade was asking another question, which is, where will she see the stipulation that we are not seeking legal fees? And that is not going to be on the website tonight if anybody goes to look, but we will put something up there. Essentially a stipulation from us confirming that we are not seeking fees or costs from any of the residents.
Thank you
for that clarification. Is this something that we just have to consistently check the website to see if
you are killing me.
we're going to get a date of when this is posted?
My intention, Sade, is tomorrow morning to put together the language in a format that can be posted that ensures all the residents that that concern need not be there, that we are not seeking fees or costs from anybody.
So essentially, Sal, are you contemplating a letter on your letterhead confirming that the BHHC is not seeking any attorney's fees?
Yeah, I want to think about exactly the best way to do it. I may actually put it on the caption and in a form of a one-sided stipulation where we're simply stipulating that, anybody who that we are not seeking those fees and costs. That's not what the purpose of the litigation is.
Well, I mean, we're all coming to the same place. So it will be there. It will be up on the website as soon as possible. And I mean, there you have it.
Right. So I would just say continue to check the Bedminster website. Just as Doug said, government drop down to affordable housing. Whether it's not going to be tonight, I guess. This other stipulation that Sal's talking about, it'll be later. Sal wants to give it a little more thought as to how he drafts it. But it will be up.
Hopefully tomorrow, Sade.
Thank you for that. And just one other question, I just want to be fast with it. There was concerns as far as just the updates with our homes. For example, my home was built in 1987, and I had to redo the bathroom and everything because, of course, that's a very long time ago with the original build. And I wanted to know, can you guys have a discussion on updating the document as far as what is qualified when it comes to reselling? I understand that, yeah, $30,000 on a kitchen will definitely put it over, but I'm wondering if there can be some type of percentage that we can at least get back.
Sade, do you know when your unit expires with restrictions?
I don't know. I did email Heather for that clarification, but I did email her tonight asking that, so I'm still waiting for that.
Okay, so let me put this back on to Heather. Heather, there are the spending plan, and I know you guys, certainly CGP&H, something that you guys work on, money available for improvements and rehabilitation is what Sade is asking for. Does that fall within that category?
It's a little bit different concept. So rehab that we would deal with in a spending plan would be rehab that's undertaken on affordable units, under the supervision of someone like our company in order to do them, to get the unit up to code. We don't usually do cosmetic, purely cosmetic kinds of things as far as like an upgrade or something like that. A bathroom certainly would be something that we would do. But I'm not sure how those two things would come together. So I'm not sure how to answer your question.
Yeah, just for example, mine, had mold at one point, and it's just because of excessive use and just never been changed. And of course you can't live like that. So I'm just asking for a percentage. I understand the full amount may not be feasible, but at least like a percentage would be fair to homeowners, especially if they walked into a home with just original built features.
So Sade, is your question about getting money from the program or getting credit when you go to resell?
Getting credit.
Okay.
And I think that's something that we're going to need to take up with the Affordable Housing Board at some point, because like I said, you know, I just want to reaffirm it with the township as far as the way that they, the best way to do, you know, improvements as it relates to the recapture, what would be allowed and that kind of thing. So I don't necessarily have an answer for you at this time, but would like to consult with the township on the best way to do this.
Okay, thank you, Heather. And thank you, Sade, for your questions.
So we only have 5 minutes. Do you want to sum things up or?
Well, Ms. Sullivan has given me the 5 minutes warning. So why don't we take one more question? Hopefully we can knock it out in 5 minutes.
Okay, I'm just
Judith,
going to pick somebody then at random. I'm picking on Jennifer Levy.
Can you hear me?
Yes.
Okay. My question is, I know I spoke with, I guess, Ms. Sullivan like 2 days ago or yesterday. I received two letters or one letter from Ed Schmier, who I know that you're suing right now in a lawsuit or something. I had numerous conversations with him. I have notification from him saying that I would not have to pay that recapture fee. I also, I was told by Sharon DeSico that as well. And I want to know, and I haven't been served yet. And I bought my unit like 25, 26 years ago. I was going to sell it a couple of years ago. I never did. Now, if I answer this judgment, will that be considered to a judge as far as misinterpretation from that master deed from Ed Schmier?
So I'm going to put this question to Sal.
Well, I'm going to ask Jennifer, could you I heard everything you said up to the point where you said, will that be considered? And I don't understand what you're asking.
What I'm asking you is, because when you answer a judgment, when you have like, I don't know how many questions to this lawsuit.
Do you mean when you answer a complaint? Is that what you mean?
If I answer the complaint,
right?
And what I'm saying is, when a judge looks at this and he sees your answers to this complaint, would that be considered to a judge in the fact that Ed Schmier gave me a document that he misinterpreted? If you're saying that master deed was misinterpreted by the lawyer who worked for Bedminster Hills Housing, notified myself that I would not have to pay this recapture fee. Now, if I answer this judgment, because these answers go through a judge, and this gets reviewed by, I guess, a panel or a judge, I want to know, hey, some people were misinformed by the lawyer of BHHC at one point. Now, if I sold my condo, which I was trying to do in 2017 and I didn't, now you're going to say to people that have moved on, hey, we want that recapture fee because that master deed was misinterpreted by that lawyer. Is that what I'm saying is, and you might not be able to answer this because this is more for a judge, but I want to know, hey, is a judge going to say this could be considered, it's almost like, is that fair?
Let me answer your question, Jennifer. I think I know what you're asking.
Okay.
Okay. And I'm going to at first say that I'm going to avoid giving you any legal advice. So don't be offended if I tell you certain things that require you to ascertain from your own counsel.
We got 1 minute and maybe 30 seconds before Zoom cuts us off. So
I'll be very brief. This litigation, the declaratory judgment litigation, seeks a judgment that says that your unit and every other unit in the Bedminster Hills Affordable Housing Community owes a recapture fee during restrictions and on the first sale after restrictions. You can answer that complaint, you can have counsel do so, or you can file the stipulation. I can't tell you how a judge is going to read what you do or do not do. That would be inappropriate, and I can't speculate. But you most certainly, in your situation in particular, you should probably confer with your own counsel and then have them call me to discuss this.
Okay, before you go though, this is the thing, counsel costs money. You're talking 250 to 500 bucks a pop an hour, all right? I don't make a great salary. So the
Do
thing
you qualify for legal services?
well, right now my unit's market value, so most likely not. If they looked at my assets, they probably would say no way. So
well, I can't speak to that, but you know,
so
you have a right to Jennifer.
Okay.
You have a right to counsel, and the questions you're asking seek legal advice. They do. And I can't give you that advice. So I suggest, unfortunately, that you are going to have your own counsel give me a call, and I will do my best to be very brief and very straightforward in my responses.
well, okay, because then I'd have to like qualify for legal aid and I might not. So is there any group out there that would actually even help somebody like me being in this situation that I was misunderstood or given advice from the BHHC attorney that was misinterpreted to me as a homeowner? So I feel like now I have to pay a $500 fee to a lawyer where I feel like I got snowballed by an attorney from BHHC. Is that fair that I have to pay out of my pocket $500, $1,000 or something like that for an attorney to even talk to you? Is that fair?
I can't speak to whether it's fair or not.
Ms. Levy, this is the mayor. So we are coming on at this 8 o'clock. So Zoom has a tendency of just cutting people off. So we're going to try to go through this quickly. Carrie Ferraro, who is, she's actually on the participant list. She is with Legal Services of Northwest New Jersey, based in Somerville. If you go to the town website, we have the contact and telephone information for Legal Services of Northwest Jersey on there. I suggest you give them a call because, Ms. Levy, your situation is unique in that the BHHC attorney and Sharon DeSico gave you bad advice. They misread or didn't read the language in the master deed. So what does that mean to you today? 3, 4, 5 years, maybe down the road? I don't know. But it is something, just as Sal mentioned, you should talk to someone. And I think you articulately described it, that may be an answer that a judge is going to have to render and not the BHHC attorney today, which is Mr. DeFazio.
Okay, you said that really quickly, from the Northwest New Jersey person. What was the person's name that you said? Carrie something? Caro, how do I get in contact with her?
There's
Legal Services of Northwest Jersey.
In Somerville.
And if you go to the town website, on the town website, Judy, where's my letter?
Under affordable housing.
So go to the government tab, click on affordable housing, and on that page, there'll be a letter from me. And in that letter, it provides the contact information for Legal Services of Northwest New Jersey.
All right. Okay. I will try, but most likely I'll have to dish out. I have a funny feeling I'm going to have to dish out money for a private attorney on this, but that's probably what's going to happen, but whatever.
As you said, you don't make a lot of money, so your income may be more of a driver than your asset of your home. Have that discussion with Legal Services, please.
Okay. All right.
And it is 8:03, and at the risk of being cut off by Zoom, And we still have 1, 2, 3, 4, 5, 6, 7, 8 folks who still have their hands up. Doug, Sal, Heather, we can do this again in a couple more days.
Absolutely.
Yeah, and I think, Mayor, if we put up on the website, now that people know from this meeting about what's on the website and what we're going to add to the website, it may resolve a lot of questions before they come before us. So I think that's a great idea, and I will be happy to make myself available.
Okay, thank you, Mr. DeFazio. And Heather, I take it you're good with that as well? I'll take your silence as a yes.
Absolutely.
Okay, so at 8:05 or 8:04, once again, at the risk of being cut off from Zoom, I want to thank everyone for attending. I also want to thank for those who may be listening to this on a recorded basis, because we certainly know that there were more than 99 or 100 that tried to get on. We will
Post it tomorrow.
So on the town, from the town perspective, we're going to look to see if we can expand our Zoom account to accommodate more than 100 folks. And we'll also make sure that the next time we run this, we're running this. So once again, everyone is on mute until they get called on. But once again, thank you for participating. Thank you for your questions. And we look forward to continuing this. We will announce the schedule both on the township website and on Facebook, and I'm sure it will make the circles. So once again, thank you all, and thank you, Committeeman Stevenson. Thank you, Ms. Sullivan. Thank you, Ms. Ray. Thank you, Heather Mahali. And thank you, Sal DeFazio. Good night.
Good night, everybody.
Good night.
Good night.
Good night.